to do a shout out to today's sponsors, and those are Anya Gorup with RBFCU and Darcy Grivell with Vintage Reconstruction. So we're going to be giving out some gift cards at the end of today's luncheon in their honor. But before we do that, I know that both of them would like to say a little something about their companies. And so the floor is yours. Darcy, would you like to say something?
Absolutely. Thank you for y'all's time. So my name is Darcy Grivell. I'm with Vintage Reconstruction. We are general contractors, but our specialty is in insurance claim reconstruction. So we only do the bill back for the flood damage, the fire, the re-roofing, anything, the busted pipes from the snow. That's what we do. We come in and we do the bill back. I've been in business since 1987. Our office is out in Bernie, but we service all of San Antonio and the Hill Country area. We also have a custom cabinet shop on our premises, so we build our own cabinets to help expedite the process in the insurance claim. So thank you. I'm happy to be a part of y'all's team.
Thank you, Darcy. Anna, are you there?
I don't see her.
Okay, I don't see her, I don't hear. All right, so let me go ahead and do a quick introduction of the board. As I said, I'm Leah Burton, your president. We've got Cassie Thompson, our president-elect. Cassie, do a quick virtual wave to everybody. I see her on there. And then there she is. And then we've got Art Downey, our VP. Art, are you with us? There he is, all right. Clay Haddock, our secretary. Clay, let's see, Clay. Amy Atkins, our treasurer. Amy, are you there? All right, Russell Birdie. I don't see him. Richard Gonzalez. Doug Smith. And Harmon. Is Harmon with us? I don't see Harmon. Okay, and then we've got our chapter executive director, Jesus Azanza, right there. Go ahead and give him a quick wave, Jesus. All right, so if we have any new members, go ahead and do a quick wave. We have any new members joining us? Hi, Lenny, how are you? Welcome.
Thank you, pleasure to be here.
Absolutely. Anyone else wants to give a quick wave? I don't see anyone else. Okay, so before we jump into our program, which is going to be action-packed, we've got Greg and Tom here to give us our legislative update, even though Greg's it says Jenna Abernathy. That is not Jenna, that is Greg Cagle right there. So I want to make sure that I give them as much time as possible to go over the action-packed session that we all just experienced. But before we do that, I'd like to give a shout out to our committees and our committee chairs and see if they have anything that they would like to report to us. First, the awards and recognition gala. Janae, are you here?
Janae's actually on a walk with a board member. We had a surprise situation pop up in the community.
Okay, well, that never happens. Okay, so we'll move on to the golf tournament. That would be Janae as well, or Jesse. Jesse Trevino, are you with us? Okay. Is there anything that you want to report about the golf tournament, Jesus, since they're not here?
I will report, well, the golf tournament is October 8th, so we'll start gearing up for that here real soon. But the gala committee has met a couple of times, and keep an eye out for an email. We'd love your vote on the next venue for 2022. We have 5 different site selections, and so we'd love to get the membership's input on that. So keep an eye out for that.
All right, thank you, Jesus. CA Day, Lucy or Jesus?
Let's see, I don't see Lucy on the call, so I'll give another quick update. And Art, feel free to give us your thoughts as well. CA Day is August 27th. There it is. It's August 27th at the Norris Conference Center. We have 7 booths left as of this morning. A lot of sponsorship opportunities. Education is in the works. And Art, if you have any insight on that, we'd appreciate that.
We're going to have a total of 9 seminars plus a lunch speaker that should be full of interesting information.
So please feel free to reach out if anybody's looking to sponsor or to purchase your booth if you haven't done so already.
Okay, thank you, Art. Thank you, Jesus. Tom, would you like to speak about education?
Yeah, just briefly. So since we had our last chapter meeting, we have had one board leadership development workshop. in the middle of last month. It was well attended. We're encouraged. We're going to continue holding these classes at least partly on Zoom because it does provide for greater participation. We'll have a couple more classes later on in the year. We're working on an advanced class. The education committee is going to need to be getting together pretty soon to spend a little bit more time on our programming for the rest of the year. And we're always looking for members. So if you want to be a volunteer, let me know and we'll be happy to have you along.
Thank you, Tom. Membership, Amaris, are you with us? I know membership has recently met. Jesus, you want to talk to us about what they've got planned?
Yes, July 8th, 4:30 to 7 o'clock, we are having a little shindig, get-together networking event at the Tower of the Americas. Information on that will be on the website here real soon this week, and we'll send an email out as well. So save the date, July 8th, 4:30 to 7 p.m.
Thank you. Sponsorship chair, we have appointed a new sponsorship chair, everyone, and her name is Suzanne Hubbard from Mackenzie Rohde, and she's super excited to fill this role. We think she's going to do an amazing job. Suzanne, are you with us today? I don't see her, but you will be hearing from her soon. And then finally, TCAA, I'm going to just punt on that one since we've got two very capable gentlemen here today who are going to talk about the session. And so with that, I'm going to move right into Greg and Tom's presentation. As you all know, after 140 very, very long days, the 87th Texas legislative session has finally come to an end. When the filings began in November, we thought it was going to be a quiet session for property owners associations. And as we all know, that is not the case at all with the passage of this monster bill, Senate Bill 1588, which the guys are going to talk about in very great detail. I am sure that Greg and Tom would be happy to answer any questions you might have. So just go ahead and stick those in the chat function down at the bottom of your screen, and time willing, or time providing, the guys will answer your questions. I'm sure there probably will be a few. And with that, I'll turn it over to you, Greg and Tom, for your legislative update 2021.
Thank you, Leah. So Tom and I have put together a little PowerPoint that kind of walk us through some of these changes, and we'll be addressing all of the various things that have been passed. And I say passed with some caveat. They've all been passed out of the House and out of the Senate and have been sent to the governor, with the exception of one bill, at least as of this morning. Most of what we're going to talk about today has not been signed by the governor. So the one caveat is that there's some small slither of percentage that these won't be signed by the governor, but I think it's pretty safe to assume that they will. Senate Bill 1588, which is the omnibus bill that Leah was referring to, that has almost all of the changes we're going to be talking about today, was pushed very hard by the Texas Realtors and others, and I think it's safe to assume that this is going to become Texas law shortly. So with that caveat in mind, that there's still a slither of a possibility that it won't, we're going to talk about it as if it is going to become Texas law, and it's pretty landscape changing in some regards. And so today will be a great day to learn about it. We're going to talk about it and give you the nuts and bolts of it, but there are nuances to these things that may not be covered today. And you know, we're still kind of studying these statutes, and we may discover additional nuances that weren't readily apparent on first reading as we go. But this is to give you sort of the highlights of these. And I would tell you, don't treat it as legal counsel. If you've got, things you've got real concerns about, I'd say talk to the lawyer for your associations on that. But this will give you a big overview of these statutes. Before we get started, Tom, you want to add anything?
No, I think that's a pretty good intro. We've got a lot to cover, so I'll just leave it at that.
Okay, I'm going to share my screen, which I think I should be able to do here. Unless, Jesus, do you need to give me the ability to share? Where do I see?
Let me.
Oh, wait, I got it right here. I got it. Okay. Post disabled participant screen sharing.
Okay, try now.
Okay. Okay, can y'all see that?
Yes.
All right, let's see. All right. I'd like the cartoon. All right, so this is the 2021 legislative session. And there were essentially 5 bills that have been passed. 2 of them are incorporated into Senate Bill 1588. That's the ones that was filed by Representative Dennis Bonin for security measures that you're going to hear about. Just know it was incorporated into a standalone bill, plus it was added to Senate Bill 1588 through an amendment. And so we'll talk about it in the context of Senate Bill 1588. There was also a bill, a standalone bill that extended the protections of displayed religious items. That was also added to Senate Bill 1588 through a floor amendment. So it's going to be in 2 bills, both the Senate Bill 1588 and a standalone, but we'll talk about it in the context of 1588. So outside of Senate Bill 1588, there's 2 other bills that are being sent to the governor, and what you'll see. So we're really limited to 3 bills here, but most of what we'll talk about is Senate Bill 1588. I'm going to let Tom, you start. This is the first topic, and we divided them up. So I'll let Tom start with this one, and I might add some thoughts if I have some.
All right, thank you, Greg. So yeah, this first PowerPoint slide shows you that they amended 202.006 of the property code, which is the statute that requires that dedicatory instruments be filed. And it's not much of a change at all, really, I don't think. The law now expressly provides that an association may not collect a regular assessment if the dedicatory instrument authorizing the collection of that assessment has not been filed. So that's now codified in the law. I don't think that's much of a change at all.
And I'll add one nuance I saw in it. Chapter 202 is a chapter that applies to all associations, both condominium associations and associations for subdivision development. But when they define the term regular assessment for purposes of this 202.006, it's using the definition from Chapter 209, which is applicable only to associations for subdivision development. There's a potential nuanced issue there about whether this actually applies to condominium developments, but I think it's largely academic because you're not going to be able to enforce any assessments if they're not in a declaration that's been recorded. So, but I don't know if there's a potential issue lying there, but there's certainly a nuanced issue with the way they defined regular assessments. But I think it's pretty, and I don't think it changes too much. I agree with Tom. All right. So,
all right.
Tom, you're still up.
Yeah. The next part of 1588 deals with Chapter 207, which is one of the chapters that applies to property owners associations other than condominiums. And by the way, the things that did pass this legislative session have a lot more changes to the condo law than in some of the most recent past legislative sessions. So this amendment applies to online subdivision information. And the way the law was previously written, if an association had a website or a management company maintained a website, then the dedicatory instruments, your governing documents, had to be accessible. It had to be available on a publicly accessible website. So they've changed the law in a couple ways. So it still has to be posted as long as you have at least 60 lots. So 60 lots or more is subject to this posting law. Or interestingly, if you've contracted with a management company. So either way, you have to have your governing documents, the current version of them, both online and filed in the deed records. So That is going to make one change in that now the website has to be available to the association members rather than a publicly accessible website. So in some ways, it's decreasing the amount of information that the general public can get. It's not required that it be restricted to association members. It's permitted for it to be available to them. That's not necessarily an exclusive provision. So I don't think there's much more in substance there. Anything you want to add before I go into 209-002, Greg?
No, I would say the way I saw the biggest change was prior to 2021, you were required, all associations for subdivision were required to post their dedicatory instruments on a website if they had a website. Now it's saying if you have 60 or more lots or you're managed by a property management company, you have to have a website. It's not if you have a website, you have to have a website. So that's the biggest change, is that especially if you've got a self-managed HOA out there that's got more than 60 lots who doesn't have a website, that's a problem. So it's now going to require them to have a website. I'd say that's the biggest issue.
Yeah. Now this statute also goes on to define what is a management company, and it's defined in a couple places throughout this bill. But it's a person or entity who established or contracted to provide management or administrative services. So let's see.
A bookkeeper could be.
Yeah, that's
a management company under that definition. I agree. That's
any kind of administrative services. So it's about as broad as you could possibly make it, I believe.
I agree.
Okay, great.
I think the next one is actually mine. So this is the 202.01A. So this is really the extension of an existing statute. So it's in Chapter 202. This applies to both associations for condominium developments and for subdivision developments. And as it existed prior to 2021, it was designed to protect the rights of property owners to have religious items displayed on their front door. The catalyst for this law originally was the protection of mezuzahs, which is an ornamental thing that holds a prayer scroll that people of the Jewish faith usually put on their front doors or front door jambs. There's been a continuous effort, at least the last 3 sessions, to expand the protection of displayed religious items from beyond the front door to encompass the entire property, and they finally got it. And so now you won't be able to enforce any restriction that would prohibit the property owners or a resident's ability to display a religious item on their dwelling or anywhere on their property across the board. Now, there are some limitations. The association can still enforce a prohibition on the display of a religious item if it threatens the public health or safety, if it violates a law other than a law prohibiting the display of religious speech, if it contains language, graphics, or any display that is patently offensive for reasons other than its religious content, or if it's installed on common area or common element property, violates any applicable line, right-of-way, setback, or easement, or is attached to a traffic control device, street light, fire hydrant, utility sign, pole, or fixture. Now, what it doesn't limit is the height, doesn't limit the number. So year-round manger scenes, possible. Year-round dozen manger scenes on the same property, possible. Maybe year-round Christmas lights, if somehow you can show that that's somehow related to as a religious display instead of just a holiday display. One of the other provisions that previously existed, it said any religious item not in compliance with this section, the HOA had the authority to remove, which I always thought was an odd restriction. They've rescinded that. So even if there's a religious display item, the statute no longer gives apparent authority to the association to go on to an owner's property and remove that religious display item. All right. Tom, do you have any other thoughts to add to it?
No, it's pretty straightforward. It just takes what used to be just on your door, and it's your entire lot or condo unit. So it's going to allow a lot more decoration. It's going to be put out on the pretext of religious displays, and there's not a whole lot you can do about it.
I mean, some people say football's a religion in Texas, right? So,
Yeah.
Can I
Oh.
ask a question real quick?
Yeah.
Uh-huh.
So if, in the condo context, if this statute is now going to say that the religious item cannot be installed on the common element property, how is everything outside of the unit, is the common element? So if someone wants to put a mezuzah on the side of the exterior outside that doesn't constitute a unit, that this statute really is not going to allow them to do that.
Maybe in a traditional condominium development with all attached construction, like an apartment building, but if you got a site condominium with all detached units where the unit boundaries are defined as lines on the ground, like we would think of as a subdivision lot, or so it's really going to depend greatly on where the unit boundaries are. But for your traditional condominium buildings, it might not be significant, especially if the balconies are limited common. You can't put up, a big Christmas tree or some religious display on the balconies if it's limited common element. But in a site condominium with all detached dwellings, maybe.
Mm-hmm.
Yeah.
Okay.
Okay, so that takes us to 202, swimming pool enclosures, right?
Yep.
All right. So this statute, first of all, defines what is a swimming pool enclosure. So it's got to surround a water feature. It's got to consist of transparent mesh or clear panels set in metal frames. It can't be more than 6 feet high, and it can't be climbable. And then after defining what is a swimming pool enclosure, it states that you may not adopt or enforce a provision in your governing documents that would prohibit or restrict an owner from installing a swimming pool enclosure, as long as it conforms with local laws, state or local laws. But you can regulate things like its appearance, the appearance of the fence. You can establish color restrictions. The statute says you cannot prohibit a swimming pool enclosure that is black in color and consists of transparent mesh set in metal frames. So it's very specific to the kind of fence and that sort of thing. And honestly, not knowing more of the legislative history, it just seemed to me that it was maybe written by a swimming pool fencing manufacturer company or somebody like that.
Well, it's I think it was, you couldn't restrict them from installing pool enclosures that are required by local government requirements. But I think, because I've certainly had associations that want to restrict certain types of swimming pool enclosures, and there's this argument where the owner is saying, "Hey, but I'm required to do it." So I'm not sure, and I may be wrong. I think this was one of the things that was in a standalone bill initially that died and was resurrected through a floor amendment to Senate Bill 1588 in the last days of the session, if I'm not mistaken. So, okay, let's go to the next one. So this is protection of security measures. Again, this was one of the measures that was in a standalone that also got passed out of the Senate and chamber. I'm sorry, the Senate and the House, and but also was incorporated into Senate Bill 1588. They're virtually identical. And essentially, again, this is adding a section to Chapter 202. Chapter 202 being the chapter that has all the provisions that are applicable to both condominiums and generally to condominiums and to associations for subdivision developments. However, this particular one specifically says, although it's located in Chapter 202, it is not applicable to condominiums. So just know this is a provision that applies only to subdivision, what I call subdivision associations, even though it is in a Chapter 202 provision. And essentially what it says is that a subdivision association may not adopt or enforce a restricted covenant that restricts a property owner from building, or installing security measures, including but not limited to, so this is an inclusive but not exclusive list, a security camera, motion detector, or perimeter fence. I don't think there's a lot there on the security camera or the motion to detect stuff. I think those are not a big deal. I think perimeter fences are, because what we're talking about is front yard fencing. Most communities, subdivision developments have restrictions that says you can't have a fence located near the front line than the front part of the building. So you can enclose backyards, side yards, but not front yards. Those will no longer be enforceable as a result of that. In addition, it's an inclusive list, meaning it's any type of security measure, not limited to those three categories. And so what we're talking about here is anything that people want to argue is a security measure, but I would tell you one that I think is problematic: burglar bars. Somebody puts burglar bars in the house, you drive into that neighborhood, what's the first thing you think of? High crime rate. There must be a high crime rate in this community. I think burglar bars are, personally, I think they're ugly, but I also think they send the message this is a high crime area. I think that's going to have a huge effect on values if somebody starts putting burglar bars on their houses. Now, like all of these, a lot of these provisions in Chapter 202 that restrict the enforcement of a type of covenant, they'll always sometimes come back and say, but here's the few things you can do. And no exception here. It does say an association can still adopt and or enforce rules that prohibit security cameras on common area property, and you can adopt and enforce regulations on the type of fencing installed for perimeter fencing. I think they didn't define security measures, which means it's going to be left open to the courts. I also think it invites homeowners to make arguments that anything might constitute a security measure. I mean, somebody could put up a huge billboard in their front yard that says this home is protected by Smith & Wesson and argue that that's a security measure, right? And now, even though we've got restrictions that says no signs, now we've got an issue about is that a security measure? So I think it's a problematic bill. I think it opens up Pandora's box a little bit. I think there's some bad things that could happen, but we'll have to wait and see how the courts interpret it. Tom, do you have any other thoughts on it?
I think you covered it pretty well. I would say the thing that is probably the biggest battleground is going to be the perimeter fencing. You're right about that. But it's so broad that it's going to provide lots of fodder for litigation in the future, I'm sure.
Yeah, fodder for abuse. That's what it'll be.
Yeah.
Okay.
All right. So the next one is mine, and that's resale certificates. So they start off by defining management company, and they refer us back to the definition that I talked to you about a little while ago in 209.002, and that's anybody who's contracted to provide management services or administrative services. But then it goes on to discuss resale certificates. There's a limitation now, there wasn't before, on the specific dollar amount. It was previously the law that you could charge a reasonable fee. Now you can, once this law is signed into law by the governor, and I agree with Greg, I think this one will probably get signed into law. There'll be a cap, and that cap's going to be $375 for a resale certificate, including the copies and everything else. And it's got to be a reasonable and necessary fee. And then for updates of resale certificates, there's a $75 cap. So that's going to cut into some management companies' revenues, I'm sure. But then the statute gets even worse. In 207.004, there are penalties for failure to comply with the statute by providing the requested subdivision information. So if you get a second request sent by certified mail for a resale certificate and you don't meet your obligation to provide one, then the owner can file suit against the association, and the remedies that are available are, number one, a court order requiring you to first furnish that information. Secondly, there could be a judgment against the association for not more than $5,000. without saying sort of how you figure out what that amount is. And then the up to $5,000 for what I'll call damages. You could be subject instead to a judgment for reasonable fees incurred by the owner. And then finally, the fourth option. So your options are get a court order requiring it be produced, $5,000 or the attorney's fees, or number 4 is both B and C. You can get a credit on future assessments for both your damages and for your reasonable attorney's fees. And, you know, this statute, I think, is very bothersome. It doesn't say anything about how the damages are to be set or calculated. I think there's also potentially an argument to be made that in the absence of actual damages, that constitutes punitive damages, and there might be a legal challenge to that there. So, but the really big thing is the cap on the fees, $375 and $75.
I would add to that, Tom, I think there's no ability for that to increase over time. And so it's set at 375, but you know, there's no, you know, automatic increase for inflation or anything else. And so this is going to be 375 in perpetuity absent another statute or amendment. And you start trying to push a new bill that says, hey, we just want to be able to tack on more fees. I don't know how well that gets perceived up at the Capitol. So, you know, a cap on at 375 is bad, but no ability for that to be increased over time, I think is going to be problematic for some folks. But I think you're right on everything else. Let's get to the next topic.
Hey, Greg.
Yeah, great. Oh, good.
Sorry to
Yeah.
interrupt again. We're having questions that are coming in. Would you
Oh.
rather, if the questions pertain to the slide at issue, would you rather just answer them at that time or just hold them all to the end?
Yeah, for some reason, because I'm hosting the PowerPoint, I'm not able to see any of the chat.
Okay, okay.
So if you want to interrupt, because I think whichever lawyer is handling that particular slide might be the best to talk about it. Let me do it
Okay.
backwards. So if
Okay.
there's some chat, why don't you just interrupt and just ask the question? I can't see it though. Just know I can't see
Okay.
it.
All right, I'm happy to do that. So we got a question that says, does this bill adjust the timeline for delivery of the first resale request?
No.
Is there a
And I
time?
would add to that, I've spoken to one management company that said, well, we normally charge a fee, an expedited fee, right? If somebody wants it within 2 days, as opposed to whatever the statutory requirement is, can we still charge that? And I said, yeah, of course you can, right? You can tell me, well, we're going to wait till the very last day to give it to you. But if you want it sooner, we're going to charge $100 or whatever you want to charge. There's no cap on your ability to charge expediting fees. There's no, if they want you to fill out additional things that go beyond the things required in the resale certificates, and I know some lenders require all kinds of questionnaires to be filled out, you could require additional fees for that as well. So this is strictly limited to the fees you can charge to produce the information laid out in the resale certificate, if that's helpful to know.
Here's another one. Is there a time frame that defines updates? How long needs to pass before it's considered to be a new request again?
There is, I don't have the statute right in front of me. If Tom has it, he could probably tell you that there is.
Yeah. Let's see. That was one I had not studied up for in advance. So
There's no change because of this bill. It's still the same. I want to say
I thought it was 30 days.
it says in section 207.003 F, which I don't believe was changed by this statute. What they changed is C. So F says this: not later than the 7th business day after the date a written request for an update of a resale certificate delivered under subsection A is received from an owner, title, an agent or title company. The property owners association shall deliver to the requesting party, essentially, an updated resale certificate that contains the following language. So, and then G says a request for an update must be made within 180 days of the resale certificate issued. So the deadline to provide a requested resale certificate is 7 business days. And when it becomes a new resale certificate as opposed to an update is after 180 days.
Danae would like to know if the bill includes anything on statement of account requests or refinance statements or just resale certificates. Just resale certificates, right?
Just
Yeah.
resale certificates.
That's correct.
Okay.
Yeah.
All right. Ken would like to know when would each of these become effective and how long does Abbott have to sign?
The effective date for almost the entire part of this, the entire bill is September 1, except for a provision that Greg will be talking about in a few minutes. And I believe the governor has 30 days to sign.
And I would add the religious items or the display of the religious items part. That was one that was contained in a standalone bill. That bill has already been signed and it is effective immediately. So even though Senate Bill 1588 hasn't been signed yet, the standalone bill for the display of religious items has been, and it had an effective immediate date on it. So that is Texas law today, just to be clear.
We got somebody in the chat, Zach Ioki. Hello, Zach. He says governor has until June 21st. So thanks for that contribution.
All right, going back to a couple questions on the religious displays. A question we got from Clay was if the governing documents are more restrictive in the size of the religious display, do those apply?
No.
Okay.
You can't enforce it if you're not going to be able to do it.
Okay. Timothy, our documents provide an 18-foot setback in the front yard. Can we prohibit displays in that area?
I believe so. That's what it says.
Yeah.
Another question from Tim. This is with regard to fences. We currently allow fences only in the backyard. Can we continue to prohibit front yard fences? Also, we limit to 4 feet high. Can we continue to do that?
I think you could probably limit the height of it. You could regulate the material of it. They're going to be allowed to. Well, I don't know about the height actually, because if they want to say they need it as a security measure, that you might be prevented. And that's one of those nuances we might have to wait and see. Because the carve out didn't allow for the height, but you're not going to be able to prevent front yard fences. You're only going to be able to regulate the construction material for those fences.
Judy has a good question here. If there is a smaller HOA inside a larger HOA, probably a master subdivision section situation, can that smaller HOA piggyback off the larger HOA's website to meet the requirement for having one?
I have to go back and look at that exact language. I think it talks about an internet website maintained by the association or a management company on its behalf. Potentially, but when we get to the management certificate, you have to identify the website address. So as long as you're able to ensure that your documents are on there and you identify your management certificate, I think you should be fine.
Yeah, I don't see how anybody would have a valid complaint if your web address is something that you're sort of just tacking onto.
Yeah.
That's all the questions for now, guys.
Okay, let's get on to management certificates. All right. So Senate Bill 1588 modified section 209.004 Texas Property Code, which tells you it's only going to be applicable to associations for subdivision developments. And what they've done is they've slightly modified what's already required to be in management certificate. So originally it said you had to identify the reporting data for the declaration. What they added on was, and all amendments to the declaration. It's got to list everything that are all basically, I would say, your declaration and all amendments. You're also now required, instead of just the mailing address of the manager, you have to identify the manager's telephone number and email address. You have to identify the website address at which the dedicatory instruments are to be published. Now, I think that only applies to lots that are managed by a management company or have 60 plus lots. You're going to have to identify the amount and description of any fees charged related to a transfer of property. They don't really define that. So I'm not sure if they're specifically limiting that to transfer fees, but I think that could include sort of reserve contributions, right? Where every time a property is conveyed, the buyer has to contribute some money to a reserve. I think that you're probably going to have to, because that's related to a transfer of property. So I think that that's pretty broad. Now, we normally see that in a resale certificate, but now it's going to have to be in a management certificate as well. And on top of all that, it's got to be recorded in the official public records of each county in which a portion of the development is located, and it needs to be amended within 30 days of any of the information reflected on there changing. So it's a continuous obligation. You can't just record it once and be done. You need to be updating it as we go. Now, and then one other new thing, within 7 days of recording it in the local official public records, you've got to electronically file it with the Texas Real Estate Commission. And this is an interesting thing, whether you like it or not. I think a big push of the Texas Realtors was to provide for more transparency and a way to easily identify who to request resale certificates from, and to easily get access to the governing declarations and that sort of stuff. So that's why I think you're seeing the changes in the resale certificates, but also you're seeing the management certificates having to be filed at the Texas Real Estate Commission. Currently, if you want to go find out the management information of every HOA in the state of Texas, you got to go to 254 different counties and hope that you can find where it's indexed, because every clerk sort of sometimes indexes them differently. This is going to provide a single repository for all management certificates, and it says for the purposes of making them available to the public. So now real estate agents or anybody should be able to go to the Texas Real Estate Commission website once it gets going and be able to find the management certificate, presumably for every association. And on top of that, they've added a new additional remedy for failure to record a management certificate, or to timely record and file with the Texas Real Estate Commission an amended management certificate. And it says that if the association hasn't done that, the owner cannot be held liable for attorney's fees or interest associated with unpaid assessments during the period a management certificate is not recorded in the local official public records and with the Texas Real Estate Commission. So, from our perspective as a firm that does assessment collection, one of the things we have to check, when we get a new collection matter, is we're gonna have to go and check the management certificates to make sure that, that we've got an updated one there, so that we can try to collect any incurred attorney's fees. So I think this is going to add to the due diligence of both management companies and law firms.
Yeah, and what I'll say is it's the duty to update that I think is going to catch a lot of people, because information like who your management company is, or a simple change of address, anything like that has to be included in an updated management certificate. And this is a trap for associations that don't get their management certificates filed, to just be left out in the cold and have to eat not only the assessments that should have been paid, but the interest and attorney's fees.
And along those lines, one thought, if you've got a management company and you use, let's say, the specific manager assigned to your community's email address, and then that manager leaves and you just reassign a different manager, you may have a problem with having the wrong email address. It might make sense for management companies to create a standalone email address that says resale certificates at blank, 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 .com, so that there's a consistent, email address or telephone number that's used, and not use any that are tied to a specific person at a company. Because I can see that happening, where you don't think to update your management certificate because the management company hasn't changed. So I think it's a trap. I agree with Tom. I think that for a good lawyer who's trying to stop an assessment collection case, or to stop the owner from being liable for all of the attorney's fees incurred, right? That's a trap waiting to happen, to be sprung.
Yeah.
As Kathy would like to know, does the management certificate need to be amended with assessment increases?
No, that's not one of the items that are required to be disclosed in the management certificate.
I'll just conclude this by saying, Greg's right. There's a specific new remedy, and some of these statutes don't provide specific remedies until you get to the one that deals with the JP Court that we'll deal with later. But this one is, this is going to be very harsh for some associations.
Yeah. All right, let's move on to one of the more interesting things, which is the new architectural rules.
Yeah, and I'll address that. So before this bill was thought of, it was almost universally the case that architectural review by whatever committee or group that you decided to name to do that was by and large not subject to board review and reversal for denials. This bill changes that. There are lots of associations that assumed that if the owner got a denial from the ACC and they didn't like it, that they could go to the board and ask the board to change their mind. So now this statute makes that permissible. And it starts off by defining architectural review authority so that it's intended to cover all those kinds of governing authorities for review and approval of improvement. So ACC, Design Review Committee, whatever you want to call it, Architectural Review Committee, they all fall under this statute. Now, it only applies to subdivisions that have more than 40 lots and they're outside the development period. You know, some of these statutes set the number at 40, some at 60. So you really have to pay attention to the specific numbers if you have one that comes up, because they change from statute to statute. It goes on to specifically disqualify from being on the architectural review authority any person who's in one of three categories: a current member of the board, or their spouse, or a resident of their household. And so there's a conscious effort there to make sure that there is some independence between the board and the architectural review committee. I'm sure that so there just won't be rubber stamping denials. But then this statute not only gives, we'll talk about the review here in a minute, but the next part of it says that a decision from an architectural review authority denying an application or request for construction may be appealed. And when you give them a denial, you've got to give it to them in writing by certified mail, hand delivery, or electronic delivery. So email would be okay. And then the notice has to meet some requirements. It has to describe the basis for the denial in reasonable detail and changes, if any, that would make that denial an approval. So that's, I think, a huge change, because previously architectural review committees, in the absence of some provision in their governing documents specifically mandating them to be specific as to the reason for the denials, commonly haven't done that. And now they're going to have to be very specific, and you're going to have to tell them why it was denied, what they could change to get approval, and tell them they can request a hearing before the board. And then there's a hearing procedure that's similar to the kind that you might be familiar with enforcement hearings, where within 30 days of receipt of an owner's request, you have to schedule a hearing. And at the hearing, the statute makes clear both the owner and the board of directors or their designated representative are to each be given an opportunity to discuss the basis for the denial, what can be done, and that sort of thing. So this is not a one-sided exchange. It has to be an interactive process. So this hearing requirement is supposed to be met within 30 days, but the statute does give both the board and the owner the ability to ask for a tip for requesting a postponement. And it's required that it be granted if it's not more than 10 days. the statute, like the enforcement hearing statute, also provides that the association or the owner may make an audio recording. So not necessarily somebody setting up a video camera, but if they took out a tape recorder or their telephone and started recording the conversation, they could do that. And then finally, the last part of this is that the board can affirm, modify, or reverse in whole or in part the decision of the Architectural Review Authority. So this gives the board sweeping power that by and large they never had before. And this is going to add expense to the architectural review process. You're going to have to give them specific reasons for denial. And I think Samantha is asking the question, is there a timeline for requesting a hearing? So
30 days.
Yeah.
It's similar language that you do in a 209 notice. You have 30 days to request the hearing with the board from the date of mailing the written notice or delivering the written notice by certified mail, hand delivery.
Yeah, and you have to actually tell them they have that 30 days.
Yep, you do.
Yeah. So let's see. Was that everything in the chat that addressed this?
No, we
does-
had a
no.
question.
Yeah.
John. Go ahead, Tom.
So does the division of the ACC and the board members apply to associations that are developer controlled? No, the statute is inapplicable to developments that are inside the development period. So developer controlled architectural review authorities continue to be valid. And then there's another question about a certain time frame for holding the hearing, and that's another 30 days subject to the 10-day postponement.
And well, I don't want to cut you off, Tom. I had a couple additional comments.
No, that's fine. Go ahead.
So here's where I see a couple of the big issues on this. Although it's not common, I've certainly have communities I've represented where the declaration explicitly provides that the board of directors shall exercise all architectural review authority. So there's not a separate body, separate and apart from the board who makes those decisions. I think this statute is going to be really problematic, and it's going to potentially force them to have to do a declaration amendment to create a separate group to make those decisions, because by statute it's saying that those people can't make those decisions. And so I think that's a problematic aspect. The second thing, and this may get to more constitutional issues, but it's pretty well established the legislature cannot enact laws that modify contractual obligations to people, private parties to a contract. And this is a significant modification of the contractual obligation structure of the declaration, where the declaration says this one body has the mutually exclusive power to approve or deny plans. And you're saying, well, no, we're gonna modify that contractual relationship to give it to a separate party. I don't know if it'll ever get up to a court, but I think there's some legitimate grounds for challenging that, to be honest with you. So I think that's somewhat problematic, but I think for now, we're going to have to treat it as valid for now, but there's some potential problems there.
We have just a few more questions. Don would like to know, this will override governing documents that state that the ACC is independent, correct?
Yes. Yes,
Do-
the statute expressly provides that that the board, that the decision may be appealed to the board. So,
But only denials, not approvals, only denials.
right, it's only denials. But they can, it's no longer independent, regardless of what your governing documents say.
That's right.
Do the management certificate requirements apply to condos?
The changes in law to the management certificate is within Chapter 209, so it's specifically only for subdivision associations. It does not apply to condominium associations.
Art mentioned that the
By the way,
penalty,
same thing with the resale certificate fees. That does not apply to condominiums as well.
Art
something
said
that we-
the penalty assessed on the HOA, the certificates are handled by management companies, not HOAs. I think Art has an issue with that.
Well, I would say that if an association is held responsible for some dereliction of duty by the management company, then there's going to be an issue between the association and its management company about who's going to ultimately bear the responsibility for that loss. But if it was wholly a failure of the management company to do something, I can imagine there being some requests for the management company to make good on those.
As to the current slide, how will this impact boards where the committee chair is a member of the board?
Well,
It can still be a non-voting member.
yeah, but it's going to render them, technically, they can't even be on the architectural review authority. So it's pretty much going to disqualify them from any effective participation.
Who facilitates the hearing, makes the decision, the board or the ACC?
Well, this is a board hearing, so it would be run by the board. The ACC at this point of the process is out of the picture.
Right.
Are there any changes regarding the board's power to appoint or remove ACC committee members?
Other than the disqualifications.
Right. No, just who can't be on it, not anything about, things that you might establish otherwise in terms of eligibility standards.
That's it for questions.
All right, we're going to move on to the changes to the board meeting procedures for subdivision associations. So Senate, one of the next changes, Senate Bill 1588 modified Section 209.0051 of the Texas Property Code. Again, this is Chapter 209, so it's applicable only to subdivision associations. Previously, as you know, it gave you two different alternative methods for providing board meeting notice. You could either mail it 10 days in advance, or you could post it and then email it to owners who had given you an email address 72 hours in advance of the meeting. They changed that timing. So if you use the second method, which is posting it and emailing it, that now must be done 144 hours in advance if it's a regular board meeting, but it remains 72 hours if it's a special board meeting. So just know that they've doubled the time for regular meetings. And then we always refer to it as the magic 15 items that have to be discussed and voted on by a board at an open board meeting. It used to say adoption of an annual budget or any amendment to the annual budget that increased it by more than 10% had to be done at an open board meeting. They've modified that to say the annual budget and any amendments, regardless of the percentage of difference or increase, any amendments to the budget have to be approved by the board at an open board meeting. I don't think those are too controversial or complicated. I think they're pretty straightforward.
No, it's just going to make it a little bit more difficult to hold prompt board meetings with things that need to be addressed. But as long as it's not one of the magic 15, decisions can be made outside of meetings and then memorialized in the minutes of the next meeting.
That's correct. The other thing I'm sorry, Lee, did you have a question?
A couple people had some questions.
Okay.
Does this include declarant control?
To the extent that yeah, well, there's a normal carve out in 209.0051 for declarant control, and it did not modify that carve out for declarant control.
Would committees like the architectural review that operate under the board but don't have board members on them have to post agendas 6 days ahead of the meetings?
No.
The rules about open meetings and notices, in the absence of provisions in your governing documents to the contrary, apply only to meetings of the board of directors.
Right.
Will the association be required to file the property code changes as part of their documents?
There's a lot of changes here, and there are going to be some that are going to probably either require amendments of existing documents or adoptions of new ones. I think that's something each association is going to want to talk to their lawyer about. For instance, you may want to adopt new rules regarding perimeter fences. Like that's just one example. There will be some other ones that we'll get into, I think, in the next few slides, where you may want to adopt some other rules or modify your religious display rules, because you're no longer talking about doors, the front doors, you're talking about the yards, and you can have some slight limitations. So there's a number of things you might want to address, but yes, that's something I think every association is going to have to take into consideration.
Any other questions?
In fact, the next slide is one. Let's just jump to it. So one of the other requirements or modifications that Senate Bill 1588 did is they modified section 209.0052 of the Texas Property Code, which deals with the approval of contracts by subdivision associations. And it added a provision that essentially says a subdivision association that proposes to contract for services that will cost more than $50,000 must solicit bids or proposals using a bid process established by the association. So I think you're going to have to adopt a bid proposal procedure because you're going to have to comply with one that's been established. And if your documents don't already have a competitive bid submission proposal process, you're going to need to create one. And this is kind of a vague statute. It doesn't define what does it mean by 50,000. Is that 50,000 collectively over the term of the agreement? Because that might make it, every management company, if it's a 12-month management company agreement that through the term of the 12 months would exceed $50,000, you now have to go through a competitive bid process before you can enter into that contract, and it doesn't talk about that. What do you count renewals? If there's an automatic renewal provision, how do you count or establish the value of it? And that's one that on its surface, I think looks pretty straightforward. But when you start getting into the nuances of it and thinking about various vendors who provide services to your associations, it starts to raise some questions that we just don't know the answer to yet. I think, at the very least, if you've got a 12-month, term on a management agreement, you're going to have to count the entire, value of that agreement, at least on the monthly management fees. And that might mean having a, competitive bid process. That's going to be something new. And association is going to have to adopt a policy or procedure for that.
Greg, what they've amended here is 209.0052, and that deals with contracts between members of the board or their family or their companies, right?
Well, it does. That's what was the initial part of it, but this is not limited to those types of agreements, I don't believe.
Let me see here.
Because those contracts between interested contracts between the association directors already requires competitive bidding process.
Yeah, but they put it in 052, which talks about contracts between board members, their family, or their companies. So that's the whole thing. So I suppose that might be an area for disagreement between council as to whether this applies to all contracts or just those with board members or relatives or family.
We had a comment, this is burdensome, just had pool renovation bid received for 165,000. Now we have to have a procedure? Question mark?
Well, it's going to apply on a going forward basis. I think the effective date of this one is September 1st. I'm on a laptop, so I only have the PowerPoint in front of me. I don't have any of my notes. So I'll say, I'm pretty sure this was one that takes effect on September 1 going forward.
You don't have the statutes memorized yet?
Not yet.
All right, question, does the competitive bid process pertain to condos as well as subdivisions?
No, this is a Chapter 209 provision, not applicable to condominium associations.
That's it for questions for now.
Okay.
All right, well, that takes us to the reporting of delinquent accounts to credit reporting companies. So this is an amendment to Chapter 209, so that it doesn't apply to condominiums. And it modifies the enforcement statute, which is 209.006. Now, whenever you're going to take certain kinds of enforcement action against owners, you have to first send a certified letter and meet all the statutory requirements. So those things, the 4 things before this bill was passed were suspension of rights to use common area, filing a suit that didn't involve assessments or temporary or foreclosure, or levy a fine or report a delinquency. So what they've added now is to report any delinquency of an owner to a credit reporting service. So that's now one of the things that you can't do unless you give proper notice to the owners and give them the opportunity to request a hearing. Then with respect to the actual credit reporting, statute says that association cannot collect or report or the collection agent cannot report as delinquent fines, fees, or assessments if they're subject to a pending dispute. And the statute goes on to provide a 30-day advance notice to the owner that they're going to be reported, and provide them with an itemization of what they owe and give them an opportunity to enter into a payment plan. So, this last part of the statute is going to bite some management companies, because it says here that an association may not charge a fee to an individual property owner for this credit reporting under subsection B. So if the management company has a fee for credit reporting in its management company's in the contract of the association, it's an obligation of the association because it's contracted to pay it, but it can't be passed along to the owners like you can most costs of collection. This is specifically excluded from that. So and this doesn't pertain to other things that you might do, like instead of going to a credit bureau, referring it to a collection agency. That would be different. This statute specifically pertains to lodging a report with a credit reporting agency. So a lot of associations don't do that, so it won't have any implication on them. But for those who actually file credit reports, you're going to have to be worried about whether it's subject to a pending dispute, and make sure that you provide the necessary notices. Anything else, Greg?
Yeah, I would say the problem is if they're refusing to pay it, is that a pending dispute? They don't really define dispute. Does it mean lawsuit, or does it mean I just don't think I owe it? What if you don't hear anything but they're not paying it? Is that a dispute? It's so vague. It just leaves this open question, or at least give room for an argument to be made that, hey, you reported this on you reported it in my credit report, and I didn't pay it because I didn't think I owed it, right? And what does it mean to be in dispute? If they send an email to one of the board members, but not the entire board, and not the manager, and says, hey, I know I owe some amount, but I don't think I owe all of that. Is that a dispute? Is that enough to constitute a dispute? I'm not sure, and the statute's very vague on that. So I think it creates some potential issues down the road.
Monica would like to know, is there a time limit for the payment plan? 6 months, 10 months? Because their documents only allow a 6-month payment plan.
It's whatever your payment plan guidelines policies provide.
Does the statute provide for definition of the bid process, i.e. public bids? I believe this change would only require you to document or memorialize your current bid process. Is that an accurate assessment of the requirement?
Well, it's whatever bid proposal process that's been established by the association. So it needs to be memorialized, whatever that process is. It doesn't get into the specifics, but whatever that process is, it probably needs to be more memorialized, and I would say recorded in a policy in the property records.
All right, we're at the 15-minute mark. You guys good on time? You want me to hold questions?
Yeah, I mean, we've still got 7 more slides. I think we'll
Okay.
burn through a bunch of them quickly, but let's see how we do. real
Okay.
quickly.
All
All
right, we'll
right,
just
so
hold
let's
some
move to
questions.
the next one. Yeah, let's hold questions and see if we can't make some progress here. And why is it not letting me? Okay, there we go. All right, so the next one is sort of, not sure what to make of this one, but back in 2011, legislature enacted section 2. Well, this says, no, that's a typo on my part. This was it should say 209.063. Sorry, it says 202. It really should say 209.063. So 209.063, the Texas Property Code, again, applies only to subdivision associations, but it created a priority of payment schedule that says any payments received by the association must be applied first to outstanding assessments and current assessments, then attorney's fees that are subject to the assessment lien. And then it says any other attorney's fees not subject to the assessment lien. Well, what they did is they inserted the word reasonable in front of attorney's fees. So now it must be it doesn't say that I'm not sure if the intent was to limit your ability to only recover reasonable attorney's fees, or that only reasonable attorneys, the money gets applied only to the reasonable attorney's fees before any other attorney's fees that are non-reasonable. I'm not sure if this is creating a trap or not. Texas lawyers are required to only charge reasonable attorney's fees. So I'm just not sure if this is a non-substantive or a substantive thing that creates a trap. But they've added the word reasonable there. I don't know, Tom, do you have any other thoughts on it?
No, I think this is just the legislature poking lawyers in the eye by saying everything's got to be reasonable. I mean, you're right. It's the only way to recover attorney's fees if you can prove that they're reasonable and necessary. That's just fundamental part of being able to recover them. So this is really just more spiked by the legislature, I think.
Yeah, I tend to agree. The next item is a modification of, again, the same typo, should say 209.064. I apologize for that. So 209.64, again, part of chapter 209 only applies to subdivision associations. This is the statute that talks about collection agent fees. That said before you can hold an owner liable for the fees of a collection agent, which is mostly the lawyers, you have to send them a notice. You've got to tell them exactly, what are the amounts owed, what's the payoff amount, what are the payment plan options. And it used to say, and you had to give them 30 days before any further collection action could be taken. Well, that's been extended from 30 days to 45 days. So they increased that time period before you can refer it over to the association's attorney. You now have to wait 45 days instead of 30 days. So not a lot there, just a longer period of time. All right. Tom, you want to talk about the hearing modification?
Yeah. I thought this was almost as interesting as the Architectural Review Authority statute. This is a change to the statute that applies to associations other than condominiums. And by the way, I saw a question on the chat about co-op associations. Texas, we divide you into 2 categories. You're either a condo or you're not. And if you're not a condo, then you're subject to Chapter 209. So this statute amends 209, and it deals with what if somebody gets a violation notice. As we discussed a little while ago, now you have to send them a violation notice if you're going to do referring them to a credit reporting agency or these other things. Well, if they submit a request, then you have to have a hearing, and 209 is the hearing procedure. So the association now has an obligation that it never had before. At least 10 days before the hearing, the association is to provide the owner who requested the hearing with a packet containing documents, photographs, and communications relating to the matter the association intends to introduce at the hearing. I mean, that's the kind of formal evidence production procedures you have in lawsuits. And it doesn't come out and say exactly what happens if you want to use something that's not in the packet, but I think there's a pretty good argument that if you didn't provide it in advance, it can't be used. If you don't provide a packet by the deadline, then the owner is entitled to an automatic 15-day postponement. So if they're entitled to it, and it's automatic, I don't think they even ask. I think you just move the hearing date by 15 days, unless the owner wanted to have it on a particular date and you could just reach an agreement as to that. And then besides the packet of evidence is the presentation of the case. You know, in enforcement hearings in my own practice, usually after everybody arrives, we thank the owners, tell them what we that we're here to listen to their story about their side of whether they're in violation. And then it's usually the association, the board and its representatives listening to the owner, maybe asking questions. But it's in the past typically been largely the forum for the owner to put on their story. Now, the association is first required to present your case. It's either through the board or through a representative, which could be your lawyer or manager, but you have to lay out your evidence and explain why it is you believe they're in violation. And you've got to do that first, by the way. So owners are entitled to get out all your evidence and hear all your arguments before they ever open up their mouths. And the statute that says you will provide them with the packet and that you shall first present the case, then goes on to say that an owner is entitled to present the owner's information and issues relevant to the appeal or dispute. So new hearing procedure in that now you've got to provide the evidence in advance. There's a postponement if you don't. And there's now a more formalistic, legalistic way of presentation of the evidence. It doesn't really go on to say, you know, anything about the decisions made following the hearing. It just discusses more the hearing process.
Yeah, I agree with everything you said, Tom. The way I've kind of viewed this is I used to think that these hearings, as initially conceived, were more of these informal mediations, right, where the owners could come and see if they could work out some sort of compromise or agreement before the association could file a lawsuit or fine them. Now it takes on this tone of an adversarial proceeding with an appointed prosecutor who presents the evidence against the owner. I think it really changes the nature of this type of forum. I think it changes almost kind of the intent and the utility of it. Ultimately, though, the board can still make whatever decision they want. That wasn't changed. I think you're right, Tom. There may be some repercussions that if you didn't present the evidence at this quote hearing, are you going to be allowed to use it later on in a lawsuit? That might be a little bit of a stretch, but I could certainly see people making that argument.
And one thing that I didn't mention is that they've now eliminated enforcement hearings by committee.
Right.
It's now just the board of directors. And this applies, in answer to one of the questions I saw in the chat, to fines and broadly to everything that is subject to the notice and hearing requirements under 209-006 and 007. So that would include fines.
Yeah, so for you know, it used to be you could have a committee hear it and then they can appeal it to the board. And if you've got your violation letters have that template or that language in there, you may want to modify the template to remove that part about committees in your violation letters.
Yeah.
Okay, let's go to the next thing. So this also is yours, Tom, and it's about regulation of leases.
Okay. Let's see. We'll skip over that. Okay, so on lease regulation, a couple years ago, law was adopted to say that you can't require owners to produce their lease agreement or their application for rental without allowing redaction of a sensitive personal identifying information like your social security number, your date of birth, I mean your driver's license number. This is the law has changed in terms of what you can ask for and who you can ask about. And I think this is in some ways much more helpful to the association than the law was previously written. because now you're permitted by statute to request information regarding the contact information, including name, mailing address, phone number, and email of every person, each person who will reside at the property under this lease. And so it's not just, you know, the person who signed it, it's all their roommates and everybody else. So that's a lot more information, but now you don't get a copy of the lease. So there's no longer this provision about redacting sensitive personal information. But in addition to providing information about who's going to be living there, and I mean, even their email and phone number, you're also permitted to ask what was the commencement date for the lease and what is the term, so that you'll know how long these people are supposed to be expected to be occupying that property.
Let's move on to the next one. All right, so this is an interesting one here.
Yeah.
Senate Bill 1588 also added a new section 209.017. Again, we're talking about chapter 209, so this is for subdivision associations, not condominiums. And it says that a property owner may now sue a subdivision association in justice court for violations of chapter 209, which is I don't know what to think about this, and I certainly want to hear Tom's thoughts. But my initial thought is, okay, that if you're going to sue in justice courts do not have injunctive relief authority, so they can't order unless there's another specific provision in chapter 209 that allows them to order an association to do something. They don't have general injunctive authority. And so for the most part, you're either suing for specific relief that's specifically authorized by chapter 209, and there's a couple of examples of that, or you have to be suing for damages. But in a lot of these cases, I'm not sure how you get damages or what damages are going to be reflected by, you know, failure to give timely notice of a board meeting. But this presumably authorizes a lawsuit against the association if you fail to give the requisite notice of a board meeting. But I don't know what damages are going to be. And if the court's awarding damages, and there's no cap on the damages in this particular provision, are those punitive type fines, because there's no real damages. So it sort of leaves open this question of what this really means, but it certainly creates jurisdiction for that suit to be brought in JP court. And a lot of JP courts most JP courts, I think, in fact, maybe all of them, non-record, and the justices aren't required to necessarily be lawyers. So sometimes you have non-lawyers serving in that capacity. So it'll be interesting to see how this thing plays out. But it's going to create, I think, a lot more lawsuits because it's giving this express authority. Tom, what do you think?
Yeah, that's exactly what I think. This right here, it should require everybody to take a hard look at what their legal budget is and consider increasing it, because any owner who says that y'all violated chapter 209 in any way, again, this applies to non-condos, but you don't have to be very educated or articulate to fill out a fill in the blank lawsuit form and file it in JP court without having an attorney. And it'll certainly give rise to probably a subcategory of lawyers who see this as a feed generation opportunity. I think there's nothing good in this, not for BOAs.
No.
All right.
So this is one of yours, and this gets into the condo stuff.
Yeah. So this is out of Senate Bill 318. So it's not part of the 1588 that we've been spending so much time on. Now notice this adds, basically what it does is it takes the records copying statute and applies it to condominiums. Under chapter 209, there's a fairly detailed procedure for owners entitled to request records and how they must do it and what the deadlines are and what the penalties are. The statute that applied to condominiums just said you had to make them reasonably available during normal business hours. And it didn't have a formalistic procedure. Well, they've changed that requirement entirely. And now the inspection and copying procedures for condos are going to be pretty much the same, which I'm here to tell you, when an owner gets upset, for condominium owners, they've got a new instrument of torture for you, because records requests can eat up all kinds of time and resources. And this statute, like the non-condo statute, caps the amount of charge that can be imposed for copies and so forth to be basically the same amount as for governmental records. And so it's going to be a big expense. And then finally, the records retention requirement that already existed for non-condominiums is extended to condominiums as long as they have 8 or more units. And then I'll wrap this up by saying this is an amendment to 81.1141, or it's adoption of that, actually. One thing that y'all need to know about is when they first adopted Chapter 209, it was 209.001 through 11 or 12, whatever it was. Since that statute has been adopted, in both Chapter 209 and here in Chapter 82, they're kind of putting things between. So you will find 82.1141 in the statutes between 82.114 and 82.115. So that's not really an easy way to find it, but it imposes some significant processes for production of records by condominium associations. And I think most importantly, add some very specific penalties.
All right, last one. Here we go. So again, this was, we had 1588, which is most of what we did. Then we've got Senate Bill 318 that Tom just covered. And now we've got the last one, which was House Bill 1659. Now, House Bill 1659 is a modification to Chapter 209, so it's going to be applicable to only the non-condominium subdivision association. And it's modifying 209.0041. And 209.0041 was the declaration amendment procedures that were created a number of years ago that allowed subdivision associations to go in and modify declarations by a vote of no greater than 67% or whatever, or a lesser percentage if your declarations had a lower percentage. They're now modifying to say that you cannot use that statutory procedure if the amendment would affect a portion of the subdivision that is zoned for, contains a commercial structure, an industrial structure, an apartment complex, or a condominium. What I suspect, and I don't know, but I suspect is that, you probably have declarations out there that have, both residential and then other types of things like industrial, commercial, or multifamily. And they had provisions in there that prevented the residential property owners from modifying such parts of the declaration that regulated the non-residential uses. But Chapter 209 was being used as an end around to impose new amendments without having to necessarily get the buy-in of the non-residential property owners. Potentially, that's what I suspect. But this would prevent that if that were the case. So if you're doing an amendment that would affect portions of the subdivision development that are zoned for, contain a commercial structure, an industrial structure, an apartment complex, or a condominium, you cannot use the amendment procedures under Chapter 209. All right. So that's all of the statutes. I don't know, Lee, are there any other questions? Because I don't have the chat in front of me.
There are just a couple questions. One that with regards to architectural review, what if the HOA cannot staff the ACC due to lack of participation from its members? Is there an exception to this rule so the board can keep reviewing ACC submittals and keep moving the HOA business forward?
No.
Okay. Will photos now be required for violations?
They won't be required, but if you have them, you'll need to produce them in your evidence package prior to your 209 hearing.
Okay. Does this apply to finding as well? That was for an earlier slide.
Yes.
Yes.
Yes, okay. And that is it. And just so everyone knows, TCAA is actively writing letters to Abbott and encouraging people, keep writing letters. The veto powers, we're still a sliver of a chance. I'm sure you guys are gonna hit on that. But I'll let you guys wrap up and then I'll give you my thanks. Go ahead.
Well, I think that, these are some of the more significant changes we've seen in the last few sessions. I think 1588 is got a lot of nuances, and I've read through it a number of times. I know Tom has, and other lawyers that do what we do. And I think we're going to continue to find little nuances that weren't readily, apparent the first few times we read through it, or we might come up with unique factual circumstances that go, wait a second, I didn't think about it in that context, but this statute also kind of addresses that. So I think it's going to evolve. I know certainly how I feel about the statute will probably continue to evolve. And so there's a lot there to digest. And I think if you've got questions, and you should still have questions, talk to the lawyer for your associations about it.
People are asking about getting a copy of the webinar or the PowerPoints, presentation slides.
Yeah, we'll figure out a way to get those over to Jesus for distribution.
It's also being recorded as well. So we'll post it on our YouTube channel.
Okay.
Okay. All right. Well, thank you guys so much. If anybody has any remaining questions, why don't you just shoot an email to Jesus that we can forward to Greg and to Tom to answer, because we are running out of time at this point. But thank you guys so much. This was really, really informative and unfortunately very troubling for us and for our industry. But we really, really do thank you very much. And with that, we are going to draw some names for some gift cards before we part ways today. We've got 4 $50 gift cards that we're going to give away on behalf of our sponsors. You got to be here to get it. So Jesus, why don't you call some names?
All right. First one is Barbara Kill, CCMC. I know Barbara's on the call.
I saw her. There she is. Barbara, you want a gift card? Yep, she's there.
Next is Ken Pyland with Diamond Association Management. There he is. Ken, congrats.
Congrats.
Carolyn Thacker, is she still on the call? I don't believe so. Okay, we'll move on. Scott Lenny, or Lenny Scott. How's this listed?
Oh, there she is. She's our newbie, our new member.
All right,
Way to
congrats.
start off strong.
Good timing.
Neat. Thank you.
Brianna Espino with Avid Property Management. Brianna, I believe I saw her.
She's on there, Brianna. Okay.
Oh, hi, thank you.
Congrats. Yeah, Visa gift cards coming your way.
Appreciate it.
All right, awesome. All right, well, thanks everyone for joining today. Just a heads up, our next month's luncheon is going to be in person, so look out for information on that, so we can all gather together in person and see each other's faces and chat and network. So you'll be getting that in your inbox from Jesus. And with that, we'll sign off and say have a wonderful rest of your day, rest of your week, and be safe out there.
Thank you.
Bye.
Bye, everyone.